Council Bill 56, 2020, introduced by Liz Walsh, to amend the Howard County Code to remove the adequate public facilities ordinance's exemption for conditionally exempt residential subdivision plans.
Okay. Ms. Walsh, I don't know if you'd like to say a word or two, and I will say our speakers on this bill are Sang Oh, Brian Gibbons, Lou Mangione, Ellie Cowan, Vicky Cutrunio, maybe, Joel Hurwitz, and Hiri Hagdu. That's it. Okay. All right, so we'll start with you, Councilmember Walsh.
Thank you, Chair Young. This legislation affects the adequate public facilities ordinance that is part of our land development code. And what it does is it removes one singular exemption listed there in section 161107. And that is for residential subdivisions that were and still are conditionally exempt. And the basis for that exemption is that they had submitted a certain amount of, or a sketch plan to Department of Planning and Zoning by the date of enactment of this adequate public facilities ordinance. This is now a decades-old law. And so for that reason, we think it is time to do away with an exemption that dates back now, maybe almost 30 years. To our knowledge, the only development that is still benefiting or maybe ever did benefit from this singular conditional exemption is the Turf Valley development.
Okay. Thank you very much, Councilmember Walsh. Does anybody have any questions for Councilmember Walsh? No. Okay, we are moving on to our speakers then. First up is Sang Oh. Mr. Oh.
My name is Sang Oh. I'm Councilman for Mangione Family Enterprises of Turf Valley and Greenburg Gibbons Commercial, and testifying in opposition to Council Bill 56. Turf Valley was approved prior to the creation of...
Mr. O. Can you slow
Yes.
down just a little bit? Did you say that you were representing the Mangione family? I'm sorry, you just went so fast.
I am counsel to them, to
You're
Mangione
counsel
Family
to them.
Enterprises of Turf Valley.
Okay,
Yes.
thank you.
Okay. They will be testifying here as well. The passage of this bill can delay about 500 of the remaining units to be built in Turf Valley for about 4 years. We think this is a terrible idea and will have many unintended consequences. It should be noted that Turf Valley could have easily tested under APFO and passed the test in the past, because it wasn't required to do so. Now that we can't pass the test, the law is being sought to be changed, requiring that we pass the test. This legislation was filed without any notice, communication, or questions to the Mangione family or its representatives. No one called to ask, hey, there's an issue, what can we do to resolve it? Instead, we think this is just another attempt to change the rules at the end of the process. This bill is undoubtedly another in the long line of the D1 council members' promise of monthly anti-development legislation. No communication, no collaboration, no solutions presented. This is not the leadership we expect from county government. Under the new school surcharge fees passed last year, the Turf Valley project is proposed to generate over $1 million a year for the next 10 years. The 2018 APFO restrictions have resulted in school surcharges returning to their lowest in a decade. How are these monies going to be replaced? For 2 decades, the county has been provided with information on the residential development of Turf Valley, including its entire residential phasing schedule. These numbers have been incorporated into the school charts. The students generated at Turf Valley are accounted for in the charts. This legislation penalizes the owner of Turf Valley because the county failed to plan. The Mangione family has been working cooperatively with the county in securing land for an elementary school at Turf Valley. We need to make sure that Turf Valley remains a great place to live, work, and play. This bill won't do that. We are disappointed in this bill, to say the least. We ask you to reject this bill. Instead, work with us to identify and resolve this problem. Thank you.
Thank you, Mr. O. Don't leave yet. Councilmember Walsh has a question.
Mr. O, could you confirm you are speaking on behalf of the organization, the Mangione Family Enterprises at Turf Valley?
They can speak for themselves.
No, actually, I believe our rules say that only one person can speak on behalf of the organization.
That's if I'm taking their, I took 2 minutes, which any individual can speak. If you'd like me to speak as an individual, I can speak as an individual. This property owner.
Excuse me, Mr. O, are you a paid lobbyist for Mangione Family
Yes, I am.
Enterprises at Turf Valley?
Yes, I am.
Chair Young, I would submit to you that we have heard testimony on behalf of that organization, and that organization has elected to use Mr. O's time.
If you want to try to deny people the opportunity to give you their input, do what you'd like. There are two business owners, property owners here who would like to give you their thoughts. They have asked me to communicate thoughts. I am doing that. If you want to try to prevent people from testifying, you can do that.
Mr. O is a paid lobbyist. I expect that you probably reached out to more than one of my colleagues about this bill, and you are welcome to reach out to me as well. But tonight's proceeding, as our rules state, is the opportunity to provide public testimony. And so just as your client would not be permitted to comment to provide 2 minutes each on why this law should not be passed, I do not think I'm not depriving anyone of their opportunity to testify. Your client elected to use you as that singular opportunity for an organization.
Well, following me will be Brian Gibbons from Greenburg Commercial. I'm counsel to manage any family enterprise of the Turf Valley. Any questions for me? Thank you.
Mr. Yungmann has a question.
I might not have been listening as intently as someone else, but I thought Mr. O was letting us know he was representing that he was trying to be transparent and disclose to us that he was their attorney by saying he was representing them. I don't know, was it intended to be he was representing them in this hearing? I mean, if he had spoken as himself and not identified him as their attorney, that wouldn't have been good. We would have frowned upon that. So I think he was just disclosing he was their attorney, not that he was speaking on their behalf. He's not signed up as speaking on their behalf on our login sheet or on our agenda.
Mr. Mangione can testify as an individual as well. This is silly. Why are we talking about this?
Ms. Walsh?
We're talking about this because we saw the same thing happen with the Glenelg Country School ZRA. And that is that a corporate client pays for testimony, as many minutes as they deem necessary to make their case. And so I think that is an abuse of the process. You read the rules at the start of this hearing. We don't allow constituents to hire attorneys and say their 3 different opinions on 2-minute intervals. I think this is no question, Mr. O, a sophisticated counsel taking advantage of a system. But he started his testimony by saying he was testifying on behalf of Mangione Family Enterprises at Turf Valley right after you started this entire public hearing by reminding everyone of the rules, which is each organization gets 1 witness on its behalf.
Again, Mr. Mangione can testify as an individual, and so can Brian Gibbons, or on behalf of GG Commercial. This is not worthy of a discussion. I could understand your point, Ms. Walsh, if I dragged in 15 lawyers here to speak to the point. That's not what I'm doing.
Ms. Schwartz-Jones, could you remind us what the rules say?
Sure, I'd be happy to pull up the rules. Give me 1 second. Oops, just passed it. Okay. It is, well, the time is modified here, but it is, in this case, it would be 2 minutes per person, whether they're speaking as an individual or on behalf of an entity. And then if there's an entity with multiple representatives speaking on behalf of the entity, it's also 2 minutes. So this would be, I'm looking at 1.012 B2. Modified for the virtual hearings where the timelines were reduced.
Okay.
And nonprofits, organizations have a longer period of time. They have the 3 minutes.
Right.
But it is 2 minutes for each representative of an entity with multiple representatives speaking on behalf of the entity.
So multiple representatives
Yes.
can speak on behalf. Okay. All right. Okay, we're moving on. All right. Brian Gibbons. Mr. Gibbons?
Good evening, Council. My name is Brian Gibbons. I'm the Chairman and CEO of Greenburg Gibbons Commercial. We are a retail-driven mixed-use development company with offices in Owings Mills and Annapolis, and we are the developer of the Turf Valley Town Square in Turf Valley. Our other projects throughout the region include Hunt Valley Town Center, Annapolis Town Center, Foundry Row in Owings Mills, Watt Chapel Town Center, and the Village at Watt Chapel. Personally, until just recently, I was a 31-year resident of Howard County and raised my family there. Prior to 2010, the only Greenburg Gibbons project in Howard County was for the Soccer Association of Columbia, which we developed for the club on a pro bono basis. Given my long history in Howard County, when the Mangione family approached us in 2010 about Turf Valley, I was thrilled to have a project in my own backyard. We wanted to provide a first-class, grocery-anchored community project together with authentic, locally owned restaurants and shops. In short, we set out to create a top-notch location for the community to gather, to shop, dine, and socialize, including hundreds who attend our summer concert series each week in the summer. We were able to attract the California State Teachers Union to co-invest tens of millions of dollars with us and secured Harris Teeter as our anchor and signed 19 local restaurants and shops for one reason: the promise of new residential housing due to the government-approved build-out of Turf Valley. Many of our projects are large regional projects, drawing customers from 25 miles or more. Turf Valley is not a regional project. Turf Valley is a local community center that caters to and relies on local residents to patronize the project. After a lot of hard work, the town square opened in 2013.
I'm sorry, but time's
Because
up.
of slower than expected pace of residential development in Turf Valley, we experienced a very slow start. We, our partners, and our tenants have hung in there and continue to reinvest in order to preserve and enhance this
I'm sorry,
valuable
but time
community
is up.
gathering spot.
Thank you, Mr. Gibbons.
Nope.
Your time is up. We appreciate your testimony. Next up is Louis Mangione. Mr. Mangione?
Can you hear me?
Yes, we can. Good evening.
Good evening. Louis Mangione from Mangione Enterprises of Turf Valley, the owner and exclusive developer, in conjunction with Greenburg Gibbons for one aspect of Turf Valley. For over 30 years, Turf Valley has worked with the county to consider all aspects of good development: schools, roads, utilities, housing, and commercial. Now, out of nowhere, with no prior notice, no prior communication, with all due respect, a council person from another district has introduced this legislation with the apparent purpose of stopping development at Turf Valley and only Turf Valley. What problem is it trying to resolve? Is it trying to eliminate hundreds of construction jobs associated with the development? Is it trying to put an additional burden on the heavily burdened retail partners we have in restaurants? The Turf Valley Hotel, Conference Center, and Country Club is going through the most difficult economic times we've ever experienced. We've managed to maintain most of our employees, and quite frankly, we have relied on the development to fund those huge operating deficits. Passing this bill will not magically open the school chart or relieve overcrowding. For over 4 decades, we have been partners. We've been good corporate citizens and are proud of our partnership with Howard County and the projects we've added to this county. We are stunned by this targeted legislation targeted at Turf Valley and no one else. Hopefully, this legislation was well intended, but it fails in both effectiveness and fairness. Thank you very much.
Thank you, Mr. Mangione. Up next is Ellie Cowan. Oh, I'm sorry, I didn't ask if anybody had any
She's for
questions.
smart growth also. She's an association.
Okay. Before Mr. Mangione leaves, does anybody have any questions? No. Okay. And Ms. Cowan, I understand you
Yes.
are representing an association, so you have 3 minutes.
Yes,
Okay.
great, thank you, thank you. Thank you for the opportunity to testify tonight. My name is Ellie Cowan. I'm the Director of Advocacy at Preservation Maryland, the Acting Director of Smart Growth Maryland, and tonight I'm here to present testimony in support of County Bill 56 on behalf of the Smarter Growth Alliance for Howard County, which is an alliance of local and state organizations working together to foster healthy, equitable, and sustainable communities through smarter development, transportation decisions, and improved protections for the county's natural and historic cultural resources. We strongly support the intention of County Bill 56 to ensure that all new residential housing be required to pass the APFO tests for allocations, public schools, and roads as a condition of approval. Howard County is at a transitional point in its development. There's less land available for future development, and infill and redevelopment, along with rezoning, are the most likely ways that new residential subdivisions will occur. The APFO tests are a way that the county can ensure that there is sufficient public facilities, roads, schools, sewer, et cetera, capacity to handle the new residential development, and is a way to manage overdevelopment. Allowing for exemptions undercuts the purpose of the APFO and can result in undesirable traffic issues, school overcrowding, et cetera, for all residents of the county, not just those directly connected or right by the new development. We believe that the opportunity to update the APFO or to address infill in new and innovative ways for restoration and redevelopment of residential subdivisions is available to us as the county works to update the general plan. And to mitigate the issue in the interim, we ask that the council approve CB 56 and the removal of the APFO test exemptions. Thank you.
Thank you. Up next, maybe, is Vicky Catrunia. Ms. Catrunia, we're calling upon you again.
Hello?
There you
Hello?
are. You're here. You're with us.
I'm really sorry. My computer crashed. Really great timing. And it had my testimony on my computer, but I'm going to try and wing it a little bit. So I apologize. I'll be brief. This is in regards to Turf Valley, because really it's the only development that doesn't have this APFO exemption or APFO restrictions. And we've been able to survive by moving out pre-K programs, and we put in an addition at Waverly that gave us 172 seats. Unfortunately, as soon as we did that, they are currently at 119% capacity. We have nothing in the near term, and I'm speaking as an individual, let me put that in there also, to address the capacity issues in the northern part of the county. Manor Woods, we redistricted and a number of students to Triadelphia, but they're back up at 100%. St. John's Lane is 124%. Hollyfield Station is another one that's 118%. There's nowhere to go. And so speaking as an individual, I'm fully in support of this legislation because it's really the only option we have to try and control the enrollment in the northern part of the county. Turf Valley has generated hundreds and hundreds of children. So and coming in the near term, we have Chapelgate that's going to be coming online with, I think, 79 townhomes, or probably more than that, and more already going development in Turf Valley that's going to generate more and more kids. So I just wanted to bring that up, that we really are in sort of a crisis situation in the northern part of the county. And this is just a way to help stem the tide a little bit until we can get some more elementary school capacity online.
Thank you, Ms. Catrunia. Any questions for Ms. Catrunia? No. Okay. Up next is Joel Hurwitz. Mr. Hurwitz?
Am I on?
Yes, you are. Good evening again.
Joel Hurwitz, Columbia. I only realized this bill over the weekend. It surprises me that the sketch plan's taking 35 years, I guess. As I pointed out when you all repealed the DRA, I said that there were other methods of getting the effect of a DRA, and this is one of them. So, in effect, you have a DRA that going on to 30 years with the sketch plan apparently from 86. So when Mr. O says that they'd have to wait 4 years, I'm surprised of how long they've already been willing to wait on their build-out plan for this project. So perhaps there's, I guess, a compromise between, but if this was a DRA, you would have the right to cancel it under the DRA rules. I also point out that my reading of the forest conservation PUD exemption was intended to apply either to Columbia and also to Turk Valley. So they're exempt in other ways as well in the code. So I guess you might have to work on the details, but I understand the problem. And as I said, I'm surprised that this has been going on so long, is buried in the code. Thanks.
Thank you, Mr. Hurwitz. Any questions for Mr. Hurwitz? Okay. Harry Hagdu? Oh, I'm sorry. Councilmember Rigby.
Man, and then I was waving my hand so hard, I think I almost forgot my question. But,
Sorry.
Sorry, Mr. Hurwitz, I just wanted a little clarity about your last comment. You said that, tying it to the beginning, you said that there are other ways of essentially having the contract the same outcome of the DRA, but through different methods, and that this would be one of them. So when you said you were surprised to find this buried in the code, is that what you mean, that it would be more clear, more readily available through having a mechanism like a DRA?
I guess in part, it took me several hours to try to figure out who this even applied to. I had to go back through the history of the section of the code to find out that the subtitle was from 1992, to then figure that part out. And then I was surprised that anybody would have a sketch plan that they haven't built out from that long. I would have assumed that they would have already built that part that they had sketch plans for under their original plan. Does that answer the question?
Yes, thank you. Sorry, thank you.
Ms. Walsh.
And I guess to address the issue that Mr. Hurwitz raised is we have not gone back and looked at exemptions that inure exclusively to Turf Valley on the subjects of other topics like, for example, forest conservation or affordable housing. This is just a straight shot at school capacity.
And I guess I would just ask you, Ms. Walsh, do you think that there are exemptions for Turf Valley that apply to forest conservation and affordable housing?
I'm not sure.
know.
I just as Mr. Hurwitz said, it took our office with help from the LA's and Office of Law some time to figure out where even this exemption derived from. We thought it was an agreement, and then we couldn't find the agreement. So I agree. This is buried in the code. It does not name the singular beneficiary of that provision by name, but there is only one. There has only been one, and again, this legislation, looking squarely at school capacity, is the problem we're trying to solve in CB 56. There may be other problems, but that's what's at issue in CB 56.
Okay, thank you. Any other questions for Mr. Hurwitz? All right, seeing none. Our last speaker on this bill is Harry Hagdu. And are you speaking for himself or on behalf of HCCA? Okay, so you have 3 minutes, Mr. Hagdu.
Okay, thank you. Good evening again. The Howard County Citizens Association would like to thank Councilmember Liz Walsh for this legislation that would end exemptions for conditionally exempt residential subdivision plans from the adequate public facilities ordinance. We commend her continued efforts at increasing accountability and addressing the decades of mismanagement that has led to woefully inadequate public infrastructure. Our county is dealing with the adverse consequences of the countless residential projects over the past few decades with little or no consideration to public infrastructure. The HCCA encourages responsible growth with proper growth mitigations to address overdevelopment. This has not taken place, and as a result, our schools are overcrowded with the last count of portables in schools north of 234. Class sizes are going up. Our public safety capacity is constrained. Roads are congested, and we don't have the funds to deal with states of emergency and shock events such as COVID because our contingency funds have largely dried up. Terrible zoning and land use laws have in effect created inequitable conditions where developer profits are subsidized while the taxpayer is asked to cover these costs or bear terrible infrastructure conditions. The fiscal impact analysis shows this will affect around 536 homes. It further states that this will result in deferred or lost tax revenue as well as corresponding expense. What the fiscal impact study does not quantify is the net effect. For decades, the county has approved residential projects by only looking at the revenue side of the project instead of the net effect by accounting for the expense. As a result, the taxpayer has been saddled with financing over 60% of the capital projects through bonds, while developers pay less than 1.8% of this cost. Furthermore, since 2011, the county has spent an average of $100 million per year servicing these bonds. This unsustainable trend continues as the county contemplates projects such as the new cultural center. We urge passage of this legislation. Thank you.
Thank you, Mr. Hegde. Are there any questions? No. Okay. That ends our testimony on CB 56. And next up, CB